Well, welcome to my online classes, second 8 weeks class and full semester. Here we are on April the 24th, beautiful spring day, recording the last of our chapter lectures, chapter 15. As we mentioned before, when we take our final, it will cover chapters 9 through 15. It's been a wonderful semester. I think I've learned a great deal just reading the exchanges that you've had in your message boards and the contributions that many of you have made throughout the semester in your group discussion projects, your research papers, so I certainly appreciate that. Keep up the good work, get ready for that final. That's the last chapter of the text in a sense, of the class in a sense, as you wrap everything up with the work that you do there on the final. So don't discard it, continue with your dedication and do well there. And part of that final will be chapter 15, the Supreme Court. There you can see the Supreme Court building, not too far away from both the White House and Capitol Hill. And so if you go to Washington, D.C., you have the opportunity to go visit the Supreme Court. And you can actually go, once you get a ticket, a certain amount of space available. But at the Supreme Court, when they're hearing their oral arguments and they have attorneys present to argue a case, you can go in and participate, in a sense, by being an observer and watch the Supreme Court in action, the Supreme Court building. We know that what's captured, I think most of you do know, and this is, of course, the way to set this chapter up for this semester. We have the death of Antonin Scalia, who was the senior member of the Supreme Court. And with his death, there's a vacancy on the Supreme Court. There are only 8 members of the court right now. And think of chapters 12 and 13. Chapter 13, the president appoints, and the president has made an appointment. The Senate confirms. In the Senate, the majority, we have mixed divided government. Think back at chapter 9, political parties. That if you have divided government, there are times in which it's very difficult to get much accomplished, and this is one of those areas. The Senate is not moving on that appointment. So you have a vacancy, and you have an even number of Supreme Court justices. There is no set number of justices in the Constitution. So in this situation here, you have 8 members of the Supreme Court. 4 could be the case in a ruling, and that means it's a tie. And if it's a tie, that means the lower court's decision stands. So that's an opinion by the court. In that sense, it means that there's no definite opinion one way if there's a 4-4 tie. So that's a situation that we may start to see more of until that's ever resolved. What does it matter about the court? The court, at least in our current structure of government, has a great deal of authority because the other 2 branches of government have, in a way, given that authority to the Supreme Court. They've decided that it's up to the court to make these decisions, and they'll let those decisions stand. Even though when we look at the issue of judicial review, as you read through this chapter, and you can go back to chapter 2, when judicial review was first brought to our attention, the ability to make a decision on the constitutionality of a law, that's not firmly defined in the Constitution. But as long as the executive and legislative branches yield that authority to them, then that will continue to be their authority, and the courts have a great deal of power in our current structure of government. As an example, overruling a decision made by a state legislature. In California, as you read here on page 615, the California legislature had passed laws limiting the opportunities for young people to buy violent video games, in however way that was deemed to be violent. The court overruled that, believed that that was a violation of the First Amendment. It's up to parents to make that decision on what games their children can use, purchase, and play. So regardless of how we feel about video games, it is once again a case of a non-elected body, the Supreme Court, overruling a decision made by an elected body, the California legislature. And so throughout this semester, we've given examples of the power of the Supreme Court And so your text brings some of these to our attention. Brown versus Board of Education, dealing with, of course, ruling against segregated school systems. Gideon v. Wainwright, the right to have an attorney even if one cannot afford one. Lawrence v. Texas, the ruling against sodomy laws that are only dealing with one area of sexuality, in this case, same-sex sodomy laws. That's a violation of the 14th Amendment. McDonald v. Chicago, the city of Chicago that had banned handguns. Now notice then, Lawrence v. Texas is overruling the Texas legislature. McDonald v. Chicago is overruling the Chicago city government. Brown versus Entertainment Merchants Association, as we just mentioned, dealt with the California legislature. United States v. Jones is a case that rules on putting GPS devices on cars, that there needs to be a search warrant. So this is not necessarily overruling an elected body, but it's overruling policies by local police forces in that case. And so there we can see on so many different areas the power of the court throughout our class that we've talked about that. And that last case is mentioned in Chapter 15. So last year there were a couple of major cases that the courts ruled on that had some huge impact in our interpretation of government. The Affordable Care Act was ruled to be constitutional in King v. Burwell, and Obergefell v. Hodges, same-sex marriages ruled as constitutional. And this then would overturn laws that had banned such marriages in those states. And so there we can see in 2015 a couple of very powerful decisions made by the court. Also, though, some ones that perhaps didn't get as much attention. Glossop v. Gross, the use of midazolam in executions, not a violation of the 8th Amendment. That is a case from Oklahoma. And Michigan versus Environmental Protection Agency, I think this is interesting because we're always talking about the power of bureaucracy, and here's a case of the agency, the court's ruling against the agency, did not interpret the Clean Air Act correctly by not considering the financial impacts on companies when enforcing regulation. So in other words, to enforce a regulation, you don't consider just the environmental impact. You also, the EPA must also consider the economic impact on the company. Now notice, of course, this is a state that's been in the news quite a bit recently on its environmental issues, and that's the state of Michigan. So once again, we're reminded, in this case by limiting the power of the Environmental Protection Agency, of the power of the court on so many different areas of our lives. So this is the current makeup of the court. At 8-member court, usually the courts have had an odd number, which means that there would normally be a majority. There could still be a plurality decision, or a justice could abstain and you could still end up with a tie, but less likely if you have an odd number. But now with an even number, with 8 justices, you can see there that there's a greater likelihood of a tie if it's a very sharply divided court. Now what you can also see here is that you've had some justices that have been on the court for a while, especially there Anthony Kennedy. You can also notice there that John Roberts, the Chief Justice, does not have to be the most senior justice. In fact, you can see there Roberts is roughly in the middle of the pack when it comes to seniority on the Supreme Court. So that when there's a vacancy for the Chief Justice, the President decides who will be Chief Justice and could pick someone outside of the court. So this is our youngest member of the Supreme Court, Elena Kagan, that was appointed by President Obama. The senior member of the court in terms of age is Ruth Bader Ginsburg. So let me just alter that to be accurate. This is the oldest member of our court currently, Ruth Bader Ginsburg, appointed by President Clinton. And then again, Chief Justice John Roberts. Age is not the factor in appointing a Chief Justice. It's up to the President and confirmation by the Senate. So that was the situation there for when President George W. Bush had the opportunity to make an appointment. I think it's a very legitimate question that we bring up from time to time when we cover this topic, and we've had some of the discussions about that in the discussion boards. Should there be a term limit for members of the Supreme Court? So John Paul Stevens served from 1975 to 2010, appointed by Gerald Ford, and served up until the Obama administration. So that's a long time for one person to be on the court, and how long should someone be on the court is a very fair question. And the power that they're able to accumulate, also about their health issues, their mental and physical health, and their ability to do the job. They hear about 100 cases a year, so the ability to stay focused on those issues can certainly be a factor for anyone on their age, but certainly even more so as people continue to age, and how much emphasis should that be regarded, the issue of how long they've served and their age and their mental and physical capacity. The power of the Chief Justice, so I'm really going back to that case just briefly, that's just something to stick in your mind about the Supreme Court. Should there be a term limit for members of the Supreme Court? Here we can see the power of the Chief Justice. The Chief Justice, if is in the majority, the Chief Justice has the authority to assign the author of the opinion of the court. So who will write the opinion for the other court members? That's the power of the Chief Justice. And usually there's just one person to write that opinion. So that's a great deal of power given to the person who writes the opinion, and then of course the power of the person who assigns it. And so the Chief Justice will be the one who assigns it if the Chief is part of the majority. If the Chief is not part of the majority, as we can see here in the second bullet point, that's where it becomes very important, the issue of seniority. So the senior member of the majority will be able to assign the author of the opinion. There's different kinds of opinions. One of those opinions is dissenting opinion. So you could have a 5-4 decision, 6-3 decision, 7-2 decision, and so you have a majority opinion. That opinion's written by the people on the majority, of course, but those who disagree with the majority can write a dissenting opinion. It does not change the viewpoints of those writing the opinion, but it may very well change opinions in the future, and that's the goal of those who write dissenting opinions. Thurgood Marshall, first African American on the Supreme Court, consistently wrote dissenting opinions in the late 60s through the 70s on the death penalty. When the majority of the justices would write in support of the death penalty, Thurgood Marshall would write against the death penalty, a dissenting opinion. And Justice Marshall's point was the permanence of the death penalty and the reality that human beings making up the law enforcement system and the law adjudicating system make mistakes. And how do you rectify a mistake if the person that's the victim of that mistake has now been executed? So that was the power of his dissenting opinions, and I would say that they're still very powerful opinions to this day, and the reason to write a dissenting opinion. There can be a plurality opinion. I briefly mentioned that you have more than 2 opinions, and so there's no majority. So if you ended up, think about what we have right now. If you had a 3-3-2 opinion, 3 different opinions, needless to say, then the opinion of the court on that particular issue is not going to be very powerful. Cases that go directly to the Supreme Court make up maybe 1 or 2 cases a year. So it's a small percentage of their overall caseload. And this is from the Constitution then to say these are cases that would go directly to the court. So just spend some time looking that over. Usually it's the first 2 of these examples that would involve the Supreme Court. Cases between 1 state and the United States, cases between 2 or more states. And you can certainly think about water rights, for example. How a river meanders through different states, and then the question is, who has access to that water and who has access to that river. how can that river, if one state utilizes a river in a certain way upstream from another state, what kind of impact does it have on the downstream state, and what rights does that state have? So we can imagine that that can be a very important issue on pollution, and irrigation, hydroelectricity, and so the court would review treaties and review previous law, and then the 14th Amendment would be a big part of what they would do in that area. But this is a small percentage overall of the cases that the courts would review. So the vast majority of their cases fall, there's two areas of jurisdiction, original jurisdiction and here appellate jurisdiction. The vast majority of the cases fall under appellate jurisdiction. The loser of a case can appeal to a higher court to review the proceedings. Why would a case be heard by the court? So if there are thousands of cases a year that are appealed to the Supreme Court, people have lost at a lower level, and now they ask the court to review what decision was made at that lower level. We can see right off that most cases are never heard. So why are some cases heard? And the issues then become, above all else, the second bullet point there, ultimately everything is decided based that it's ripe. It's ripe for the plucking right there, the ripe apple to be plucked off the tree. But we can see here constitutional issues, as we've discussed, Griswold v. Connecticut, for example, that need to be resolved. A constitutional issue, McDonald v. Chicago certainly would fall into that category. Two lower courts have decided similar cases differently. That was the case with the Affordable Care Act. An important national issue. If it's a case involving the president, very likely needs to move up the ladder and quickly be decided. So Griswold v. Connecticut, that right to privacy. Is there a right to privacy, even though it's not mentioned in the Constitution? And our lives become more complicated through new successes in technology and medicine. Does that then mean that privacy is an issue that needs to be reviewed on a very frequent basis or a more regular basis? And that was starting back in the 1960s, became the case there with the birth control issue. Again, cases that need to be decided, campaign finance would fit in that category as well, gun control, ripeness. Cell phone case, that was another example there, confliction of lower courts. Do courts rule that cell phones require warrants? So if someone has been arrested and they look through a person's wallet, let's say, can they then open up the cell phone and start to just look at the search history or the contacts that they made on the cell phone, or is that private and is in need of a search warrant? And the courts have ultimately ruled that it does need a search warrant. And then a couple of major cases involving the president would fit into that example of a national issue. U.S. v. Nixon brought out in your text that the tapes allow, should the tapes be released, or is this a case in which executive privilege should take over and the president conversations are protected? And ultimately, the court ruled that the Congress's right to overview the president or have oversight over the presidency was a constitutional right, and that therefore they had that right that was more important than the president's right, which is not in the Constitution, but has been accepted, that the president's conversations with advisors be protected. So Congress won in that case. A president is a U.S. citizen. Are there special privileges given to the president? In some cases, certainly, I think we can see the reasons for that protection of the president. But can that protection then allow a president to be uninhibited or just not regarding other types of activities that the rest of us are subjected to, such as a lawsuit? So the court ruled in 1998 that the president is a U.S. citizen like the rest of us and can be subjected to a lawsuit while the president is in office. And that was the case there with Jones v. Clinton in 1998. The steps for an appeal, somewhat serpentine, I suppose, in a way. At least, well, I wouldn't say that. I guess more than anything else, there's a little bit of time involved here for sure to try to get this resolved. Excuse me there. So the lower court writes the appeal to the Supreme Court, and that's called the writ of pauperis. If someone does not have any legal assistance, they can still write out their own appeal. You have to have 4 justices decide to hear a case. And when they do decide to hear a case, they issue a writ of certiorari when the Supreme Court decides to hear a case. It commands an inferior court to turn over records of court case for review. So just think about some of the cases that we've covered throughout our time here together. Clarence Gideon, going back to, again, Chapter 4, and the right to an attorney even if one cannot afford one. So he wrote out his own appeal because they didn't have an attorney, didn't have the money for an attorney, as he was in the Florida penitentiary. And they did, in fact, decide to hear his case. Remarkable case, Gideon v. Wainwright. When you have an opportunity, you might want to just read some more about that case on your own. It's a fascinating case. All right, when the Supreme Court is in session, they will have opportunities to hear cases, and this is referred to as oral arguments. So when they're hearing a case, they will emerge behind these curtains and sit down, and attorneys step forward. Green light comes on, and they start giving their opinion. And when the red light comes on, they stop. During that time of giving the presentation, justices can interfere and interrupt by raising questions, steering the conversation a different direction if they think that that's important. And so it's formal, and yet at the same time appears to be informal, as the justices can take charge of the presentation if they'd like, and interrupt with the views of the attorneys in that case. Well, the basis for the power of the court, as we mentioned before, is judicial review. So certainly read through pages 612, 620 on this issue. And this, again, gives the Supreme Court the power to determine if a law is constitutional. And so Marbury wanted to be a justice of the peace, was not given that opportunity, as he was a supporter of the outgoing President John Adams. Thomas Jefferson becomes president, refuses then to honor these appointments that were made while Adams was still president. The person who holds on to these old papers is, at the time, Secretary of State James Madison. You see his picture there on the right. Marbury, who is on the left, sues. He wants the Supreme Court. He goes to the court and asks them to issue a writ of mandamus. And a writ of mandamus is to get elected officials to do a certain duty. And the duty here was to honor those appointments. Well, Jefferson says he's not going to honor the appointments anyway. And so in that sense, the court looks as if they're going to be weak on this, because how can they get the president to do something the president doesn't want to do? And so ultimately what happens here is the court rules that based on the Constitution, they could not issue a writ of mandamus. They didn't have the standing to do so. It appears that it makes the court look weak, but ultimately it made the court very strong, because now they become the interpreters of the Constitution. And that is what has set the tone ever since, that it's up to the courts to determine what is in fact constitutional. Marbury v. Madison, determining the constitutionality of a law, that's judicial review. Pages 612, 620, very important to read through that passage. And so traditionally what the courts have done is decided cases based on the past. So you can't always do that. There are times in which you just have to break from the past. Gideon v. Wainwright was one of those cases. Or there's nothing in the past to really base your decision. In some ways, that would be the case there at Griswold v. Connecticut, because birth control was just not something, the birth control pill, certainly not something that past generations dealt with. So that doesn't always work, but in large part what the court does is to stand by that which has been decided, the use of stare decisis. So in that sense, the court's a very traditional organization. And it's a fair question then to wrap up this chapter is to say, is that really what the court needs to do? Are there not times in which the court does need to be an activist court? You can read about this on page 630. And perhaps there's an issue that is very important that has to be resolved. And maybe the only way to fully resolve it is by having the court active. Now, if that's the case, though, let's just keep in mind we are talking about an unelected branch of government. And that's always an issue and a concern. But perhaps somebody has to step up and make a decision if you don't have the president or the court or the Congress making that decision. And that leaves us here with that question that we really, in a way, raised at the very beginning, a way to go circle here, full circle, to talk about activism in a general sense. You know, why do people need to be activists? Why do they need to take it upon themselves from time to time and say, look, if you want to clean up this creek, somebody has to step forward and say, let's do it. If you want to have a library in your town, somebody has to step forward and do that. If you think we should not have trade with China, somebody has to run for president and say that. And so thank goodness that we have people that want to be activists, that we actually, people that say, what's happening right now is not good enough. We need to do something else. And that's, I think, what is great about this country and the need for government and why we're here today, because we've had people going back to the beginning of time, if you want to look at every government, but certainly for our own government, that we have had people that said our current system is not good enough. We need to try something else. And so I hope that many of you will be like that. And you will think things over and say, is there something I can do to try to make this system better? What can I do? And I think the first step is to be educated, and then the second step is to be involved. So hopefully you'll be down that road. And you're on that way by being an educated individual, by being a college student, and soon enough a college graduate. Very good. This is the end of our recorded lectures for this semester. Glad to have you in class. Hopefully you've gotten a lot out of this. And I look forward to seeing you when we take our final. I know for some of you that won't happen, but for many of you that will be something I always enjoy doing. So there we go. All right, move on, and we'll see you in a couple of weeks for our final.